Hello again. Today we will be getting into a topic that is extremely important to business owners, supervisors, managers, you name it. And that topic is employment discrimination. Big word? No. Actually, there is a bit more to talk about than no, but that's the bottom line. Okay, we will be looking at the employment at will doctrine, constitutional provisions relative to employment discrimination, the Civil Rights Acts of both 1866 and 1871, the Equal Pay Act of 1963, the Civil Rights Act of 1964, as amended by Title VII and the Civil Rights Act of 1991. Okay. We're also looking at the Age Discrimination in Employment Act of 1967, the Rehabilitation Act of 1973, the Americans with Disabilities Act, which was huge, 1991, and also affirmative action, global dimensions of employment discrimination. Employment at will doctrine. I think we're probably all rather familiar with that. Contract of employment for an indeterminate term is terminable, can be severed at will by either the employer or the employee. Traditional American rule governing employer-employee relations, restricted by common law and state statutory exceptions, such as an implied contract for business, violation of public policy, or an implied covenant of good faith and fair dealing. So, exceptions for employment at will. Public policy exception makes it unlawful to dismiss an employee for taking certain actions in the public interest. You're not supposed to be able to fire an employee who puts themselves in harm's way during the course of their employment to save a customer. It does tend to happen, but they usually aren't very successful. Okay, implied covenant of good faith and fair dealing. This is based on the theory that every employment contract, even an unwritten one, contains the implicit understanding that the parties deal fairly with one another. You both make certain promises, you both have certain expectations. You need to abide by those promises and expectations. These are the federal statutes that prohibit discrimination in employment, and there are a bunch. Not supposed to be able to discriminate for wages on the basis of sex. Women are supposed to be paid the same amount as men for doing the same job. You cannot discriminate based on race, color, religion, sex, or national origin. You can't discriminate based upon age when the person is 40 years of age or older. Can't discriminate based on a handicap or a disability, provided that the person with reasonable accommodations can do the job properly. The two Civil Rights Acts we need to talk about, the Civil Rights Act of 1866. All persons in the United States have the same right to make and enforce contracts and have the full and equal benefit of the law. We all have the right to work and do business as we see fit. The Civil Rights Act of 1871 prohibited discrimination by state and local governments as well. The Equal Pay Act of 1963, the statute that prohibits wage discrimination based on sex, equal work for equal pay, means substantially the same in terms of 4 factors that are listed in the Act: the skill level, the degree of effort, the degree of responsibility, and the working conditions. As long as those 4 things are the same for a male as well as a female, the female should be paid at the same rate as the male. Following are legal justifications for paying unequal wages to men and women. Seniority. Well, you can't help that, you know. Man's been at a company 10 years longer than a woman. She should make the same salary because she's a woman? No. Qualified merit system. Man makes $10,000 a year more because he brings in more business, has better performance reviews, whatever criteria that must be examined. If a woman doesn't meet those things, why should she be paid the extra $10,000 just because she's a woman? No. Pay system based on quality or quantity of output. You know, if you're paid you work in a manufacturing line, you might be paid at a piece rate, you know, so much per item that you produce in an hour or a day. Well, just because you're a woman, you know, you better earn the same amount. You have no right to expect to be paid more if you do less than a male. Factors other than sex. The remedy for those who violate this act: you can recover back pay. So that can get a little spendy for employers. The Civil Rights Act of '64, as amended by the Civil Rights Act of 1991. Title VII prohibits discrimination in hiring, firing, or other terms and conditions of employment on the basis of race, color, religion, sex, or national origin. Now, this only applies to employers who have 15 or more employees that particular year or the last year for 20 consecutive weeks and are engaged in a business that affects interstate commerce, which arguably is just about everybody, right? Even the clerk at Quick Trip, you know, the Quick Trip trucks drive across states to deliver product. That's good enough. That's interstate commerce. Ways to prove employment discrimination: disparate treatment. Employer treats one employee less favorably than another because of that employee's color, race, religion, sex, or national origin. Don't pay them as much money. Don't give them the better jobs. Don't give them the good working hours. You name it. Disparate impact. Employers' facially neutral policy or practice has a discriminatory effect on an employee belonging to a protected class. It may appear that the employer is being neutral on his face, but in fact is not. Good example of that. There are certain religions who observe religious holidays that, you know, are a bit different than the majority. Treating these employees negatively because of that would not fly. You know, well, he can't work on Saturday, And that's our busiest day, but there isn't anything I can do about that. Well, that might be an instance of religious discrimination. The shifting burden of proof in a disparate treatment case, you can also think unfair or unequal instead of disparate. The plaintiff proves a prima facie case on its face. It is what it is. It is discrimination. The burden of proof then shifts to the defendant just to prove that he or she has a legitimate, non-discriminatory reason for what they did. Burden of proof then shifts back to the plaintiff to prove that the defendant's quote-unquote reason isn't really true. They're just using that as an excuse, and it is not an excuse. Ways to prove employment discrimination? Well, there are several types of discrimination involved here. There's sexual harassment, which is unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature which explicitly or implicitly makes submission a term or condition of employment or creates an intimidating, hostile, or offensive environment. Meaning raunchy jokes don't fly. Okay. There is such a thing nowadays. Well, nowadays it's always been probably same-sex harassment. We don't necessarily need to be just talking female and male. It can be male and male or female and female. Doesn't matter. Sexual harassment is sexual harassment. Hostile environment. A hostile environment is making working conditions so unpleasant that the plaintiff can no longer continue to function appropriately in their job. That typically tends to be what happens when you're talking about sexual harassment. The more it escalates, the more difficult it is for the victim to come to work and do their job effectively. That's a hostile work environment. Okay, Teresa Harris versus Forklift Systems, Inc. Teresa Harris alleged that she faced gender discrimination and sexual innuendos or suggestions from the president of Forklift Systems where she worked. The district court ruled in favor of Forklift Systems, and the Court of Appeals agreed. The plaintiff appealed, Ms. Harris appealed to the U.S. Supreme Court, and they applied Title VII and said no, she was faced with gender discrimination and sexual innuendo. Sorry, that's discrimination. Retaliation. Title VII makes it unlawful to retaliate. The evidence for a retaliation claim must show that the employee engaged in a protected activity under Title VII. The employee was fired, demoted, or suffered some other adverse employment action, and employee's protected activity was the cause of or the determining factor for the adverse employment action. What does that all mean? Well, a real quick example. You feel like as though you're being sexually harassed by your boss. You take that to human resources. Your boss gets in trouble. And then your boss, gets you fired or demoted or creates a hostile work environment for you because you got him in trouble. That's retaliation, and that is illegal. Defenses for the defendant in Title VII cases. Well, a bona fide occupational qualification. This allows discrimination in hiring on the basis of sex, religion, or national origin when such a characteristic is necessary to the performance of the job. There could be a perfectly legal, legitimate reason for an employer to list a job qualification of being able to lift a minimum of 50 pounds. There's going to be some ladies out there who can't lift 50 pounds. I'm sorry, it's not discriminatory. If it is an important factor in the performance of the job that you be able to lift 50 pounds, then that's fine. It stands. That's how it is. Merit. Using a professionally developed ability test, which is not designed, intended, or used to discriminate, is legal. You know, aptitude tests, knowledge tests to find out if you're suited for a particular position. That's fine. You're testing someone's intellect, their skill set, that has nothing to do with their gender. Seniority systems. Preferential treatment based on length of service is not unlawful if it applies equally to everyone. If a man gets 4 weeks vacation after 10 years service, then a woman had better get 4 weeks vacation after 10 years of service. Okay? Follows industry practices. Did not begin with a discrimination and is free of any illegal discriminatory purpose. So, as far as seniority systems go, as long as the rules for seniority apply to everyone, that's fine. Mixed motives, proving that the plaintiff's membership in a protected class is the reason for unfair treatment. You have to prove you are in a protected class and you have been treated unfairly, and your protected class is the direct reason for that. Protected classes under Title VII of the Constitution: race and color, national origin, religion, sex, and there is also pregnancy discrimination. It used to be such a thing that back in the day, young married ladies would go out and apply for jobs and they wouldn't get hired because employers would say to themselves, the minute she has a baby, she'll be gone. Can't do that anymore. Some tips for avoiding sexual harassment charges, ye old employers and managers to be. Senior management must make clear its position that sexual harassment in any form will not be tolerated. Any form. Even a questionable joke. No. Have an explicit written policy on sexual harassment that is widely disseminated in the workplace and given to every new employee. Most places I've ever worked have posted their policy on sexual harassment in the employee break room areas. That's important. Make sure employees know what sexual harassment is and is not. And that might sound silly, but there are plenty of people who don't get it. They don't understand that even though a joke is a joke, the content can still be offensive to other people, even if it's not offensive to the person telling the joke. And that's where the problem comes in. Just because you think something is funny and you're not offended by it in the least, doesn't mean that those around you feel the same way. Okay? Provide a gender-neutral training program on sexual harassment for all employees. Like I say, it's got to be gender neutral. Male against female, female against male, 2 males, 2 females, completely neutral. Establish an efficient system for investigating charges of sexual harassment and punishing violators. If you do not see to it that people who have been proven to be in violation of this policy are going to suffer some repercussion for that, sexual harassment is not going to be reported. And that's very problematic. That results in lawsuits. Make sure that complaints are to be filed with a neutral party, not with the supervisor. A lot of times it's the supervisor-employee situation. Thoroughly and investigate and resolve every complaint, punishing those who are found guilty appropriately. If you find no violation, you must explain your decision thoroughly to the person who filed the complaint. You can't just go and say, sorry, there's no claim here. You have to explain what you did in terms of your investigation and how what you did in terms of your investigation led you to a finding of no complaint. Okay. Enforcement procedures and remedies under Title VII. Enforcement procedures. Well, someone who's been discriminated against and is not getting satisfaction from the employer, you can file a charge with the State Equal Employment Opportunities Commission. Conciliation and filing a suit. Remedies. Back pay for up to 2 years. Remedial seniority. If you were fired or you left the company as a result of this harassment and you win your state EEOC claim, you may be reinstated back with your 15-year seniority. Compensatory and punitive damages. Compensatory, lost wages. Punitive, extra money to punish your employer for not doing the right thing when they had the opportunity. And you can get your attorney fees paid as well. LEB8e, Fair Pay Act of 2009. This stresses the importance of protecting victims of wage discrimination. This restores the policy that was in place before LEB8e, which stipulates that each paycheck gives rise to a new cause of action for discriminatory pay. For a while there, it was, you had the statute of limitations to deal with if you were filing a discrimination charge for unequal pay, and they would say, well, sorry, too late, you should have filed that immediately as soon as you found out. And what this act states is, no, sorry. Every time a person gets a paycheck that is incorrect, that's a new cause for action. No statute of limitations here. The Age Discrimination in Employment Act, statute that prohibits employers from refusing to hire or to discharge or discriminate against people in terms or conditions of employment on the basis of age. Now, this act applies to employers that have 20 more employees in an industry that affects interstate commerce, most do, Employment agencies and unions that have at least 25 members or operate a hiring hall. Okay. How do you prove age discrimination? Well, you establish facts to create a reasonable inference that age was a determining factor in determination by showing that you belong to the protected age group, 40 or older. You were qualified for the position that you held or applied for. You were terminated under circumstances giving rise to an inference of discrimination. For example, you are very close to retirement, very close to being 100% vested in your pension, and all of a sudden, bye-bye, you're gone. And you're replaced with someone 20 or 30 years your junior at a substantially less amount of salary. Can't do that. Cannot do that. Okay, defenses, bona fide occupational qualification, again, requires that an employer hire employees of only a certain age to safely and efficiently operate the business in question. I have a little personal knowledge on this. I have several family members who are airline pilots, and my uncle had to retire at the age of 60. It was mandatory. Didn't matter what shape you were in. I presently have a cousin who is an airline pilot. They have now increased that age to 65 from 60, but it's still, you hit that age and you're done, period, boom. Why? Because you're up thousands and thousands of feet in the air with several hundred people at your mercy. And if something goes wrong with you, and face it, the older you get, the odds of something going wrong with you increase. It's not a risk that needs to be taken as far as the law is concerned. So that is one occupation where age is a bona fide occupational qualification. Termination based on other reasonable factors besides age. Well, yeah, you're not doing the job, absenteeism, you name it. Statutory defenses, executive exemption to this act that allows mandatory retirement of executives at age 65 if the employee was hired as a bona fide executive for at least 2 years prior to retirement, and the employee is entitled to non-forfeitable annual retirement benefits of at least $44,000. Termination upon receiving evidence of employee misconduct. So, these big CEOs that get these huge deals for retiring, what the heck? I'll check out at 65. I'll have enough money to buy my own island. I don't care. Let me go at 65. Okay. Enforcement and remedies. Enforcement. Reinstatement. Remedies. Back pay for 2 years. Liquidated damages in the amount equal to back pay if the plaintiff proves that the employer acted willfully. Compensatory damages and punitive damages are rarely awarded. Basically back pay or comparative amount. The Rehabilitation Act prevents discrimination in employment against otherwise qualified persons who have a handicap. This applies to the federal government, to employers who have a contract with the federal government, and employers in the private sector who do not have federal contracts. If somebody is perfectly equipped to do a job, even though they have a handicap, you cannot discriminate against them based on their handicap. I think I just jumped a slide. Okay. So, this was a big one. I actually remember this one when it was enacted in 1991 during the President Clinton's administration. This is the Americans with Disabilities Act of 1991. This was huge. It requires employers to make reasonable accommodation to the known disabilities of an otherwise qualified job applicant or employee with a disability, unless the necessary accommodation would impose an undue burden on the employer's business. Okay. This is why we have office buildings that are wheelchair accessible. If I'm perfectly capable of performing a job and I'm in a wheelchair, it's not unreasonable for me to expect an employer to have facilities that I can navigate around. Okay? So, a big one is employees who have certain medical conditions, some bad back, severe arthritis, what have you, buying them ergonomic office chairs so they may sit more comfortably is a big one. And that's certainly not an unreasonable burden on an employer. You can get one of those for several $100s. That's not that big of a deal. But now, if it would take an employer revamping their entire operation in order to hire someone with a disability, no, not required to do that. That would be unduly burdensome. Having to shift a lot of responsibilities for this particular job over to someone else so the handicapped person could fill this position, no. Unduly burdensome, putting too much work on someone else. Individuals covered under the Americans with Disabilities Act, individuals with diseases such as cancer, epilepsy, heart disease, blind or deaf people and infected by HIV but not yet symptomatic, intellectual disabilities, individuals with an intellectual functioning level below 70 to 75 in IQ, individuals with severe limitations in adaptive skill areas, and any disability that originated before the age of 18. Okay. When you have to interview a potential employee who has a disability, you must be very careful in how you ask questions. For example, as you can see here, you may ask, can you perform the functions of this job with or without reasonable accommodations? You may not ask, do you have a disability that would interfere with your ability to perform the job? You may ask, can you meet the attendance requirements of this job? You may not ask, how many days were you sick last year? You may ask, do you illegally use drugs? You may not ask, what prescription drugs are you currently taking? You can't ask about alcohol consumption or potential problems. You have to be very careful in how you word your questions when you're dealing with someone who has a disability. Enforcement and remedies under the ADA. Someone who wants to file a claim with under the ADA has to prove that they have a disability, they were otherwise qualified for the job, and they were excluded from the job solely because of that disability. That can be kind of hard to do, especially in today's employment market. Remedies: reinstatement, back pay, or an injunction, limited compensatory and punitive damages, and employers can be subjected to fines up to $100,000. You really need to take a hard look when you're dealing with someone who has what constitutes a disability under the Americans with Disabilities Act. Affirmative action plans. These are programs that are adopted by employers to increase the representation of both women and minorities in their workforces. But here's the kicker. That may also constitute reverse discrimination. Reverse discrimination is discrimination in favor of members of groups that have been previously discriminated against. If I'm the better qualified candidate over someone in a protected class, but that person in that protected class gets the position because they're a member of that protected class, that's reverse discrimination on me. I didn't do any discriminating, so why am I being discriminated against? Okay? Global dimensions of employment discrimination. U.S. citizens working overseas for the United States corporations are protected by our laws. The Equal Employment Opportunity Commission considers the principal place of the business, the nationality of the shareholders, and the nationality and location of the management when dealing with claims. Okay, so we've talked about a lot. The employment at will doctrine, constitutional provisions relative to employment discrimination, Civil Rights Acts of 1866 and 1871, the Equal Pay Act of 1963, the Civil Rights Act of 1964 as amended in 1991, Age Discrimination in Employment Act of 67, the Rehabilitation Act of 73, American Disabilities Act of 1991, affirmative action, and global dimensions of employment discrimination. So, this is a very tough area, and it's one that needs to be strictly adhered to, one that needs to be tracked carefully because changes do come about. Whoever's in charge of your human resources really needs to be on top of these things. That's the bottom line. Be aware, be compliant, do not tolerate discrimination in your place of business. So, here ends the chapter on employment discrimination. Have a great rest of your day, and we will see you in the next chapter.